Public Bill, second reading.
I move that the Financial Crimes Commission Miscellaneous Provisions Bill number 1 of 2025 be read a second time. Madam Speaker, today I rise before this august assembly to present the Financial Crimes Commission Miscellaneous Provisions Bill number 1 of 2025, a measure that is much about legal rectification as it is about the restoration of our nation's fundamental principles: democracy, constitutionalism, and the rule of law. This bill is not merely a technical amendment to an errant statute. It is an unequivocal statement of the new government elected by the people with a mandate to restore democracy, that it will not tolerate legal aberrations that corrode the integrity of our constitutional order. What we seek to do today is re-establish the proper balance between the branches of government, fortify the sanctity of our institutions, and reverse the legislative vandalism that was perpetrated in a manner both reckless and unconstitutional. Honourable members will remember and recall that when the Financial Crimes Commission Act 2023 was passed last year, it was widely criticised for purporting to confer on these FCC powers that directly violated the Constitution, powers that encroached upon the prosecutorial powers and role that our supreme law reserves for the Director of Public Prosecutions, and for the Director alone. This was no oversight, nor was it a mere error of judgment. It was a deliberate and calculated attack on the prosecutorial independence enshrined in our legal system. It was a move to open our criminal justice system to insidious political interference. Indeed, I can today inform the House that the version of that bill that was enacted in 2023 was not the version that had been submitted to the Director of Public Prosecutions for his initial views. It was not the version that the DPP had agreed to. No, it was a version that was further tweaked and twisted, and to which the learned DPP raised serious constitutional objections. Thus, Madam Speaker, the DPP himself had no choice but to seek constitutional redress before the Supreme Court, challenging the blatant encroachment upon his domain. And here we must pause to reflect on a truth that too often is neglected these days. That is, the law can only function effectively if those entrusted with its enforcement uphold their duties with integrity and independence. The Constitution provides, Madam Speaker, for several independent institutions, from the Commission of Police to the Public Service Commission. But how many of these actually operate independently at all times? To his credit, the learned DPP acted to defend the role attributed to him by our supreme law. And in undermining the DPP, the previous government did not merely violate the Constitution, they committed a graver offence. They undermine the very foundation of justice. Madam Speaker, let me be absolutely clear on why this is so egregious. Our democracy is built upon the principle of separation of powers. Those who make the laws must never be the ones who administer justice. This principle is deeply ingrained in our national ethos, forged through centuries of democratic struggle to end the absolutism of despots, where rulers once held unchecked powers as judge, jury, and executioners. Madam Speaker, one does not need to have read Montesquieu to grasp that something would be profoundly wrong if tomorrow a minister were to preside over cases at the Intermediate Court, for example, or if a Prime Minister were to interfere in the conduct of a judicial inquiry. However, some in this country still fail to grasp the danger of placing prosecutorial powers under political control. They argue rather simplistically, I must say, isn't the DPP part of the executive in any case? What is the problem if suspected offenders are brought to justice through government action, they ask? After all, independent judges and magistrates will ultimately decide the case. These are probably the same persons who in recent weeks have been demanding, why has the new government not yet arrested X or Y? Why has not been X or Y been prosecuted for this or that offense? To them I say this is not how our system works. If it were, and the government had the power to direct criminal investigations and prosecutions, two grave risks would threaten our nation. Firstly, individuals could be targeted for prosecution based on political motives. And we have all witnessed, have we not, in the recent years, how opposition figures, and I will not name them here, have been subjected to a barrage of provisional charges, only for these to be struck down by the courts months or years later due to lack of evidence. Secondly, members of the government or their associates could be shielded from scrutiny and prosecution. Again, we have seen how investigations into prominent figures of the previous administration have stagnated to the point of near abandonment. Madam Speaker, as Attorney General, I do not stand before this House to engage in partisan politics. Let it be very clear. But I would be derelict in my duty as a government's chief legal advisor if I fail to highlight these serious transgressions and to put forward how we can ensure they are never repeated. To avoid these dangers, these two dangers I've just highlighted, it is crucial that the government truly allows the police, the FCC, and the DPP to operate independently. If you appoint the right people in the right place, give them the means and the freedom to do their job, then, and only then, can you expect inquiries to be fair, irrespective of who is being investigated. It is only then that you can have prosecutions based solely on legal considerations, evidence, and the public interest, and it is only then that you can have the rule of law instead of the dominion of men. This, Madam Speaker, is the difference between justice and vengeance. And this is why the framers of our Constitution had in mind, Madam Speaker, and perhaps here a little history at this juncture would not go amiss. Prior to independence, at the Mauritius Constitutional Review Conference of '61, it was decided that the Director of Public Prosecution should be solely responsible in his discretion for the initiation, conduct, and discontinuance of prosecutions. He would be independent of the Attorney General, who would remain the legal advisor of government and a member of cabinet. This put an end, in fact, to the overlap that had existed until then, and which stemmed from the colonial era office of Procureur and Advocate General. The post of DPP was thus formally established through the Mauritius Constitution Order of '64. Its very raison d'être from the outset, Madam Speaker, was therefore to establish a clear and inviolable separation between two fundamental functions of the state, governing and prosecuting. That same year, Madam Speaker, Professor De Smith argued in his Constitutional Commissioner's report that the DPP should be given judicial security of tenure, as was already the case in other jurisdictions. In 1965, at the Constitutional Conference at Lancaster House in London, the principle of prosecutorial independence was further reinforced, and it was decided that only a person qualified to be a judge of the Supreme Court could act as a DPP. After independence, these provisions were retained and enshrined in Section 72 of our Constitution, which provides that the DPP is appointed by the Judicial and Legal Service Commission, ensuring insulation from executive interference. Section 72(3) of the Constitution confers upon the DPP the power to institute, take over, and discontinue any criminal proceedings before any court of law. The framers of our supreme law added at subsection 6 thereof that in the exercise of the powers conferred upon him by this section, the Director of Public Prosecution shall not be subject to the direction or control of any other person or authority. This is why, in his plaint for constitutional relief, the learned DPP described his position as being, and I quote, the apex prosecution authority. The independence of the DPP, Madam Speaker, has been consistently upheld by our courts. For instance, in 1994, a full bench of the Supreme Court observed that, and I quote, a distinguishing feature of our Constitution, like that of some of the new Commonwealth countries, is the splitting of executive functions between what one might call political executive, which remains answerable to Parliament, and an independent, non-political executive in specific matters, consisting of, amongst others, the Director of Public Prosecutions, the Service Commissions, and the Electoral Supervisory Commission, which are not answerable to Parliament. The purpose of this device, the learned judges continued, institutionally was to insulate certain areas in the conduct of public affairs from political responsibility and control, thus ensuring the autonomy and their autonomy and independence, end of quote. Similarly, our Law Reform Commission in a 2009 report described the importance of safeguarding, and I quote again, the stream of criminal justice being polluted by the inflow of noxious political contamination by segregating the process of prosecution entirely from general political consideration. And for years, statutes have respected this principle, including when the Independent Commission Against Corruption was set up, allowing the DPP to remain truly the apex prosecuting body of our country. That is, until the infamous, ill-reputed Financial Crimes Commission Act of 9 of 2023. Madam Speaker, the explanatory memorandum of this FCC bill in 2023 explicitly declared that the Financial Crimes Commission was to be the apex agency in Mauritius to detect, investigate, and prosecute financial crimes and any other ancillary offence connected thereto. That Act therefore provided at its section 4.3 that subject to this Act, the Commission shall, in the discharge of its functions and exercise of its powers, not be under the direction and control of any person or authority. A similar provision is made at section 11.3 for the role of the Director General of the Commission. Here already we'll see how a law passed by a simple majority aims to displace the DPP's constitutional prerogative under section 72 of the Constitution. This purported apex prosecuting authority is to be, as per section 7.3 and sections 10.1 of the Act, composed of commissioners, a Director General, and this is where the important bit comes in, appointed by the President, acting in accordance with the advice of Prime Minister, after the latter had consulted with the Leader of the Opposition. The terms and conditions of these appointments are to be determined by the Prime Minister alone. The possibility of political influence and considerations which endure during the tenure of the appointees is thus clear. The more so as the Constitution allows at section 113 subsection 4 for anyone appointed in such way to be required to vacate their office at any time after a general election held after that appointment. Madam Speaker, of course, a responsible and honest government would appoint to the FCC persons of integrity and moral independence. Of course, such a government would not try to interfere in the work of the Commission through secret back channels. And of course, appointees do not necessarily neglect their duties under the law to please those who put them in place. But, and this is the big but, Madam Speaker, one does not build a ship for fair weather. It is the storm that must be provided for. The same goes for our institutions and our laws. Their good functioning cannot depend only on the hope that morality and duty will prevail. There must be checks and balances to prevent any temptation to slide into the arbitrary. There must be safeguards for the day when the unscrupulous try to abuse the system, which is why as we maintain the mode of appointment of the SEC for the time being, and I stress, for the time being only, it is critical that the DPP, whose appointment is quasi-judicial, exercise scrutiny over the prosecuting function of the FCC. Unfortunately, Madam Speaker, this is not what the FCC Act of 2023 catered for. As the law stands today, after its investigations, the FCC has the power to institute criminal proceedings. Section 1421 of the Act does pay lip service to the constitutional role of the DPP by stating that the FCC's ability to initiate prosecution is without prejudice to the DPP's power under Section 72 of the Constitution. As such, it is said the DPP can discontinue prosecution in any criminal case which the FCC has lodged. That is what was advocated by and advanced by the bill's supporters in 2023. But Madam Speaker, the fact of the matter, do excuse me, I must confess I've just been appearing before the Supreme Court, so I slipped. I'm very sorry, Madam Speaker. But when the DPP is not put in presence of the file which led to the prosecution, how could the DPP in fact exercise his powers under Section 72 and step in to actually stop the prosecution? It would obviously be not possible. You see, Madam Speaker, the Prevention of Corruption Act of 2002 compelled the ICAC to submit a report to the DPP after the conclusion of an investigation. Such a report had to contain all material information, statements and documents covered during the inquiry, as well as a description of any evidence which was still in the ICAC's custody, and it had to be accompanied by the ICAC's recommendations. This allowed for the DPP to be properly informed of the outcome of the investigation and to be able to assess whether criminal proceedings were warranted or not. And he had the final say on the matter. In stark contrast, Madam Speaker, there is no such provision in the FCC Act. There is no report to be sent to the DPP. He therefore cannot be in a position to appreciate whether a prosecution initiated by the FCC is justified or not. In the absence of any information on a case, how can the DPP exercise his ability to discontinue proceedings or to step in to continue them, as the Constitution gives him the power to do? His role under Section 72 of our Supreme Law is thus severely curtailed, to say the least. Now, the aberrations, Madam Speaker, do not stop here. As at today, if the FCC decides that it will not prosecute because there is no report to the DPP, the latter may never know whether proceedings ought in fact to have been initiated. In fact, none of us would know. He may not even know that an investigation has been stopped. No one would know, not even us, because there is no obligation on the FCC to inform him. Again, the exercise of his powers under the Constitution was thus neutralized. The FCC Act does not stop there, and it goes a step further in its blatant disregard for the Constitution. Its Section 150, Madam Speaker, allows the Commission to compound any offence under the Act or under the Declaration of Assets Act. That is, if an investigation has uncovered an offence, the Commission has the discretion to grant to the offender the possibility of paying a fine or an amount not exceeding the maximum penalty. When this happens, there can be no criminal proceedings thereafter with respect to that offence. In other words, the FCC has the authority to offer to someone, against the payment of a fine, protection from prosecution, conviction before our courts, and jail sentences. And it can do so whenever it wishes to. It has no obligation to communicate on such a decision. That is so wrong. It is true that compounding does exist under a number of our statutes, mainly for offences related to banking, fiscal and financial offences. But in all of these cases, there is an obligation on the compounding authority, MRA or the like, to first obtain the DPP's prior authorization. The latter can decide that compounding will not do, and criminal proceedings should be initiated instead. The DPP has no such power when it comes to compounding under the FCC Act. What is more, he is deprived of his ability to initiate proceedings of his own against the offender, as Section 150 of the Act prevents any case from being brought against a person who has benefited from compounding by the FCC. Once again, the Director of Public Prosecutions is robbed, and there is no other word, is robbed of his prerogatives under Section 72 of the Constitution. Madam Speaker, this is the situation which this bill addresses. The different clauses of our bill aim to restore the DPP as the apex prosecution authority in our land, including for cases that fall within the FCC Act. Accordingly, Clause 5 of the bill provides amendments to the Financial Crimes Commission Act 2023 so that no prosecution for an offence under that Act or the Declaration of Assets Act shall be instituted except by or with the consent of the Director of Public Prosecutions. The Financial Crimes Commission will therefore have no discretion in instituting or discontinuing criminal proceedings under those enactments. In addition, further related amendments are being brought to the Financial Crimes Commission Act to provide that where the Financial Crimes Commission determines that an investigation should be discontinued, it shall, and there is an obligation there, it shall send a report to the DPP setting out its reasons. Where the director, in another case, if the director does not advise prosecution or any action, he may also require the Financial Crimes Commission to conduct such further inquiries as he considers fit to advise. And thirdly, any offence to be compounded under either the FCC Act or the Declaration of Assets Act must henceforth be with his consent and approval. Madam Speaker, there is also a series of consequential amendments to other statutes in order to erase the act of legislative vandalism that has been made against our constitutional order. Clause 2 of the bill provides for amendments to be brought to the courts with a view to empowering the Director of Public Prosecutions to be the sole authority to determine whether an information relating to a financial crime shall be laid before the Financial Crimes Division of the Intermediate Court or the Financial Crimes Division of the Supreme Court. Clause 3 of the bill, Madam Speaker, provides amendments to be brought to the Criminal Appeal Act to restore the right only to the DPP to make an appeal to the Court of Criminal Appeal against the final decision of the Supreme Court with regard to any offence under the Financial Crimes Commission Act and the Declaration of Assets Act. The Financial Crimes Commission was given a similar right of appeal to the Supreme Court under the District and Intermediate Court's Criminal Jurisdiction Act against the final decision of the District Court or the Intermediate Court with regard to any offence under the FCC Act or the Declaration of Assets Act. Clause 4 of the bill, Madam Speaker, therefore provides for amendments to be brought to the District and Intermediate Court's Criminal Jurisdiction Act to restore that right of appeal only to the DPP. Madam Speaker, the FCC Act 2023, a law passed by a simple majority, cannot trump, no pun intended, the provisions of our Constitution. It cannot be allowed to curtail the prerogatives of the DPP under Section 72 of our Supreme Law, and it most certainly cannot contravene the principles of democracy enshrined in its Section 1. The passage of this bill today is not simply a legislative correction. It is a moral obligation. It is a declaration that our institutions are not bargaining chips in political games, that our Constitution is not a plaything to be controlled at will. It is a message to our citizens that they can once again believe in the fairness of our law and the impartiality of our justice system. Madam Speaker, through this bill, we do not merely amend a law. We seek to restore justice, reaffirm democracy, and recommit ourselves to the ideals that make the Republic of Mauritius a sovereign and democratic state. With these words, Madam Speaker, I commend the bill to the House.